in your own words, please tell the court, when you were first made aware that you had granted the lender a power of attorney.
The first time I even knew about the power of attorney was when Legal Quest invited me to take their 3-step mortgage challenge. I was shocked to discover it was there.
Am I correct in the fact that your mortgage was arranged over 10 years ago, and that during all that time, you were unaware that the lender could act as if they were you?
That is exactly the case. At no time did either the mortgage broker or the lender explain about it, or even mention it, let alone what they could do with it.
If it pleases the court, I would like to provide a brief summary of what rights the power of attorney, in this particular mortgage, allegedly provided to the lender. As you can see, on the copy documents provided by the lender, and submitted as Exhibit 4, there are very clear and specific terms and conditions which govern this mortgage. There are 2 specific clauses which I would like you to look at. The first is the actual power of attorney, which is found under Section 17, and the second is under Section 19, which relates to the rights to transfer or sell the mortgage or benefits to anyone the lender chooses, without the knowledge and consent of the borrower. We submit that both of these clauses are and must remain key facts, and, under the FCA guidelines, should have been explained in a fair, clear and not misleading manner.
Is this the basis for today's hearing and submissions?
No, Your Honor, this is purely background information, but key to the matters before the court. Our main submission is based on what the lender did with the power of attorney. Please tell the court what actions you took after discovery of the existence of the power of attorney.
Following the guidelines of the Legal Quest 3-step process, the next thing we needed to do was to obtain a full copy of all the paperwork the lender had relating to my mortgage.
I understand that you chose to appoint Legal Quest and their legal advisors, and that they carried out a formal data subject access request to the lender on your behalf. Ladies and gentlemen, the Data Protection Act provides everyone with the right to compel any regulated firm or body to provide copies of any data held within 40 days of request. Please continue. Did the lender provide you with the requested data? And if so, what did you discover?
After several weeks, Camelus Law, the legal case management firm appointed by Legal Quest on my behalf, received the file from my lender. They then reviewed all the documents.
I have a copy of their report, and it is submitted as Exhibit 22 evidence. Were you surprised by their findings?
I was shocked to find out that the lender had sold my mortgage using the power of attorney, which you will recall I was not advised about soon after I took out the loan. According to the files, the original loan was settled in full, and the lender received the extra money from the sale, which they kept as profit. They used the power of attorney to pretend to be me, transfer or sell my mortgage, along with thousands of other mortgages, and did not tell me that my original loan was settled. And for the past 10 years, I have been paying them my mortgage payments on a loan which was settled, and they have collected the money and seemingly passed it on as an agent. All of this was without my knowledge, and although the power of attorney supposedly gives them the right, definitely without my consent.
I find it difficult to understand, as do most people, how the banking sector have been able to carry out this type of business for so many years without it being challenged. Mortgage securitization, which is the technical term for what we have been discussing today, was stated as being the single most probable cause of the financial problems of 2008. Since then, in the United States, many billions of dollars in fines and compensation have been awarded against not only US banks, but well-known UK high street banks as well. It was only a matter of time before similar claims were made here in the UK. The legal issues are complex, and it may be many months before definitive case law is established. However, There is a simple matter, which we would like the court to rule upon today. It is specifically relating to the security. My client agreed with the original lender, as shown on Exhibit 22, the interest registered with the Land Registry, as security by the lender, remains in their name. As has been proven and evidenced by documents obtained from the lender themselves, under the subject access request, the liability, to which the security specifically relates, has been settled in full. Therefore, the charge is no longer valid, the lender no longer holds the legal and equitable right to any security, and the charge should therefore be removed immediately.
Having reviewed the evidence, has the jury come to a decision regarding the matter shown as Count 1? Counts 2 to 4 have been adjourned to a later date, therefore the only matter before you is relative to the removal of the registered charge, on the basis that the lender no longer has the legal right to the security, and therefore the lender should immediately remove their charge from the records at the Land Registry. What is your decision in this matter?
We find for the claimant and award costs against the defendant.
Accordingly, the court finds that the motion for the removal of the registered charge on the property of the claimant is hereby granted, and the charge is removed within 28 days. The defendants are, in addition, to pay the claimant's legal costs and provide confirmation from the Land Registry that the charge has been removed no later than 20th March 2015,